All right. Good afternoon, everyone. We're going to go ahead and get started. Obviously, folks are rolling in, but we are being recorded. In advance, I apologize if I sound a little rough. I've been laid out for about the last week and a half with something that tore my throat up pretty good. So if at any time you're having trouble understanding me, feel free to raise a hand or give me a heads up, and I'll, take an extra sip of water or try a little harder. We should go probably the full hour. If I'm going too fast, because we have a fair bit to cover, again, please feel free to, give me a heads up. I can take questions during. My colleague, Brandon Lewis, who is joining me today, will be catching questions in the chat. And we're also joined by our IT guru, Kevin Brown, and our paralegal specialist, Kimberly Brown. So if you do have any difficulties, please don't hesitate to reach out to us. I am going to share my screen. And we will go ahead and get started. And Brandon, if at any time you lose me or the presentation, just please let me know. All right. So once again, my name is Anthony J. Scerbo. I'm an attorney advisor with the Office of Open Government. This is part of our Summer 26 FOIA legislation or FOIA webinar series for FOIA officers. I'm going to be doing an update on FY26 FOIA and FOIA related. We're going to stretch that a little bit. Legislation and litigation update. Bear in mind, this is meant to be a focused look. It is not absolutely comprehensive. I did my best to choose representative or significant cases that presented key points of law or things that, directly affected FOIA. As we all know, this is where we live within the code and then within the regs. So let's just get right into it with DC FOIA legislation in the last, year and a half, but, particularly within FY26. We're starting out with a bill that's been introduced. It's been referred to, I think, the cow, but it hasn't moved. It may be mooted, and we're going to talk about this because it relates to an ongoing thread of what we're talking about today. But this was the Council Review of Agency Action Clarification Amendment Act. It was introduced in 25. It codifies, I'm sorry, I'm misspeaking. This bill became effective. I'm jumping ahead. This was introduced by the chair, and it codifies agency deference and clarifies that a reviewing court or tribunal shall defer to an agency's reasonable interpretation of a statute or reg that the agency administers, providing the interpretation is not plainly wrong or inconsistent with the statutory or regulatory language or the council's intent. Obviously, it came in direct response to Loper-Bright SCOTUS decision, which essentially overturned, a large percentage of established administrative law. It became effective last September, right before the fiscal year started, and it is operative law. This touches on a development in the last year and a half, where specific information from courts, federal agencies, or federally established agencies, which, because of the unique nature of the district, do touch on bodies and agencies within the district. Information or data provided by any court, federal agency, or federal established agency to either the CJCC, the Criminal Justice Coordinating Council, or the DC Sentencing Commission. This came out of the prior Budget Support Act, and now, much of that information is exempted. Obviously, not all of it. District-specific information, et cetera, is still operative within the DC FOIA. The next piece of legislation is talks about the deliberative process privilege and how it would no longer be an exemption on an executive branch draft document for a DC FOIA request. This is what I was trying to allude to before. You're going to see a trend both in the legislation and the litigation when we get to it of the executive and legislative um, essentially having conflicts between the two branches regarding pre-decisional or deliberative documents, particularly related to the budget. And all of us are in agencies. We know what goes on. We read the news. This bill was introduced at the end of last year and referred immediately to the cow. This is the bill that may be mooted based on subsequent activity. But the Deadline Accountability Amendment Act sought to address the problem of missed deadlines. And it said if a deadline has passed for any report or other document the council is required by date certain, then deliberative process privilege can no longer be used to withhold the draft document from a response to a DC FOIA request. And that would specifically narrowly apply to a document that the council already required to be produced by law. Obviously, this to a large degree touched on budget enhancement request documents and other things. As I say, it currently sits in the cow, but subsequent issues may have moved past this. Further attention over the budget docs, we have the budget enhancement request litigation authorization resolution. This was a resolution by the council which authorized the Office of the General Counsel to initiate, defend, intervene, participate, or take any other action in any court on behalf of and in the name of the council to assert the interest of the council in obtaining certain agency budget enhancement requests that have to be furnished to the council pursuant to DC Official Code, Section 47, etc. This was a preemptive move in light of, the appellate decision that came out in District of Columbia v. Terrace Pravlik Million. I always do that wrong. Million. And we're going to talk about that case when we get to litigation. That process is still going on. The budget enhancement process is still going on. Obviously, we had a budget that was voted upon. It currently sits with the mayor. But primarily with respect to agency budget request documents, the council said that they intended to, if necessary, direct the Office of General Counsel to act on its behalf. Another big trend we saw earlier this year and ongoing is the issue of body-worn cameras and documentation of the presence of non-district officers or other officers present at the scene of use of force events. There were two council members who introduced parallel but not identical pieces of sets of legislation. The first was the full accountability and arrest reporting set of measures. There was obviously the resolution and the emergency. Those were passed and have since expired. The temporary became effective last month and will be effective until January. And this requires MPD officers to document identifying information for all law enforcement officers present at the scene of an arrest and any use of force and arrest reports and probable cause affidavits, and to amend the body-worn camera regs and Reporting Requirements Act to require body camera footage transparency in all use of force events. So obviously this relates directly to MPD, but there are other agencies that this may impact, and it does touch upon body-worn camera statute specifically. The parallel measures had a rockier move, but eventually, after, in one case, a veto, etc., the Transparency Temporary Act and the Temporary Act, which is now in play and will expire in January as well, requires MPD to release body-worn camera recordings in the event of an officer-involved death or a serious use of force by any law enforcement officer other than an MPD officer. Again, presumptively, we're talking primarily about the increased federal presence here in the district. A measure related to protecting the judiciary. The Protecting Judicial Privacy Act will expressly prohibit government agencies, individuals, businesses, private associations, and organizations from, upon receipt of a written request, publicly displaying available content that includes an officer of the judiciary's personal information. That was referred to the Committee on Judiciary and Public Safety with comments already attached to it from the Committee on the Whole. I think we can all agree that, that is a worthwhile, especially in light of Supreme Court testimony this week on, increased threats to the safety of our judiciary. Data privacy and protection. The DC Data Privacy and Protection Act of 26 establishes comprehensive privacy protections governing the collection, use, sale, and disclosure of individuals' personal data by district agencies and third parties, and it confers specific rights on individuals regarding their personal information. The bill is going to create a CPO, a Chief Privacy Officer position within OCTO, to ensure agency-wide compliance and implementation. A hearing was just held on this a couple of weeks ago. I haven't had a chance to watch all of it. If you have time, I suggest that you take a look at least at the part regarding data and records. It was handled out of Public Works and Operations, and I believe the recording will be up indefinitely on the council's website. Talked about protecting the judiciary. Now let's talk about protecting victims. Protecting Victims Amendment Act holds offenders accountable for repeated violations of temporary and civil protection orders, TPOs and CPOs, as well as stay away and no contact orders in criminal cases. So in part, the bill deals with personal information of crime victims. Quote, to further protect victim privacy, the bill amends MPD's public disclosure requirements to prevent the improper release of identifying information for crime victims, including domestic violence victims, as well as individuals who report on their behalf. And in the FIS of the bill, it states that district law provides for the address confidentiality program, which is administered by the Office of Victim Services and Judicial Grants, and it authorizes a substitute address for victims of domestic abuse, sexual offenses, trafficking, stalking, to protect their actual address from DC FOIA. It also withholds participants in the address confidentiality program from public inspection as required for records maintained by MPD. And it provides that victims of or witness to a criminal offense can be added to that program. It was referred to Judiciary and Public Safety in May. I checked, I believe, earlier this week, if not the end of last week, and I don't think a further action or hearing has yet been scheduled for the bill. So we're talking after the recess at the earliest. All right, moving on to hospitality. We have these new categories of licensed operations, and the DC Hospitality Amendment Act creates specifically a pop-up restaurant license category and then addresses issues that are specific to that category. So in terms of the Alcohol and Cannabis Board, the board shall make a licensee's quarterly statements available to any protestant and to any member of the public who requests it, according to DC FOIA. That will allow a protestant or licensee to determine the gross annual receipts of a licensee. So you're able to see quarterly gross receipts. However, the disclosure of a quarterly statement to a protestant or member of the public shall be subject to the same disclosure exemptions that we have under 2-534. But what it wouldn't do is give you more granular access or more specific information, which could be considered commercially, protected information for the licensee or the putative licensee. That hearing already happened about a week ago in Public Works and Operations. And again, I know that recording is up. Also, in the last month, we had this hearing at Health. This regards the Captive Insurance Company Amendment Act of 2026. For those who don't know, it had been years since I had dealt with or heard about captive insurance companies, so I had to refresh myself. A captive insurance company is a company that is created um, by a company to be its own insurance company. So it is captive in the sense that it is solely responsible to, controlled by, and owned by the company it is insuring. Captive insurance is a major nationwide marketplace. States and other jurisdictions work fairly hard to attract captive insurance for the companies when they're chartered and when they're created. There are fees and there are other things that come into the public coffers. DC is one of the largest captive insurance jurisdictions, and so there was a move on behalf of both the executive and some members of the council to update and amend. In this case, this bill makes certain proprietary regulatory records confidential. While these records could already be withheld, it exempt, where trade secret and confidential information, it clarifies the extent of confidentiality of those specific records submitted to Department of Insurance, Securities, and Banking. Primary justification for withholding records would now be, information specifically exempted by statute, because we've passed a law that says this information is now exempted, instead of relying on, possibly the inconsistent application of 534A1. This is not a universally supported bill. There is a well-known whistleblower who testified on this subject, who's dealt with captive insurance in this and other jurisdictions. Also, the Open Government Coalition, which took no interest on the whole bill, but took, specific exception to certain aspects of the legislation. That hearing is a comprehensive hearing. It covers 3 or 4 pieces of legislation, and this bill is handled in 2 separate sections. Anybody who doesn't want to hunt around for it, send me a message offline. I'm happy to provide you the timestamps for you to be able to watch just those sections. I know how valuable your time is, and I'm happy to do anything I can to help. Again, Open Government Coalition recently has sent a letter to the council. I know that the chair was asked about this at the press conference on Monday by a reporter. The Homeland Security Commission dissolution was part of the BSA, subtitled B. And essentially what it does is it dissolves the Homeland Security Commission on October 1st, the beginning of the fiscal year, and transfers basically everything over to the Homeland Security Emergency Management Agency. And then all such records and information shall be destroyed by them by the end of the fiscal year, so by 30 September of 27. It does, essentially gag people who were privileged to some of the information or confidential information, and commission members that were not open to the public, as well as all information and records generated shall be treated as confidential. And then, notwithstanding all of the things I just said, commission information records may be disclosed by HSEMA as necessary to carry out its duties and purposes. The information and records may be disclosed by HSEMA to another Homeland Security agency or Homeland Security Commission if that agency or commission is governed by confidentiality provisions that are the same or greater as those that were in the Act. And except as permitted by the provisions of the statute, the proposed statute, information and records of the commission shall not be disclosed voluntarily relative to a subpoena for discovery, etc. And that information that was, or records that were presented to the commission shall not be immune from subpoena or discovery or prohibited just because they were made available, only if the information and records that were provided to the commission could have been obtained through another different source. And then obviously in the case of that different source, it would have to be something that was subject to either discovery, privilege, FOIA, what have you. And it amends specifically, it creates a new 534A category, number 13, So that is amended to read as follows. Information exempt from disclosure by Section 301(4)(e) of the Homeland Security Commission Dissolution Act of 2026. So essentially, with the BSA, we now have our 13th subcategory under 534A. I doubt, except for anyone who may be joining us from HCMA, that this will be relevant as a FOIA officer. However, as a FOIA officer for another agency advising either your legal staff or your leadership, this may be relevant if you need or want records from either the commission or now, essentially, once this becomes enacted with HCMA. All right, I'm going to stop here for a second before we move into litigation and see, just a quick check. Anyone is welcome to come off and ask a question before we move forward. Okay, hearing none, I'm going to roll into DC FOIA litigation. Okay, as promised, TPM. TPM has been around for a number of years. This goes back to when I was still in law school. TPM is a public interest firm. They made a DC FOIA request for budget-related documents to both OSSI, the State Superintendent of Education, and DC Public Schools from FY19 to now the present. And this comes out of them. They represent a plaintiff class of preschool-age kids with disabilities. And so the orders that come out of that representation, they're doing their due diligence in that representation. In 2020, TPM sued the district, alleging that the district failed to produce and post the online docs. And they invoked 536A6A. Next year, there were motions that went back and forth. Superior Court eventually denied the mayor's motion to dismiss and granted TPM's motion for summary judgment. They ordered the mayor to produce the required documents and comply with the publication requirements of 2-536. Further, there was an order granting TPM their motion, as I said, and denying. It says District of Columbia's cross motion for summary judgment. I'm going to continue referring to the mayor because at some point the interests of the government got divided, and both the council and the mayor, and this will also be true with the budget enhancement documents, became at one point divided. And so therefore, instead of referring to the government, even though that's the named defendant, I'm going to refer to the mayor's office because they were representing the interest of the executive, OSSI, and DCPS. So Superior granted the motion and they ordered, eventually the court stated its enforcement of the order because the mayor indicated they were going to appeal to Court of Appeals. So that happened in mid-late 21. The argument before the Court of Appeals, which was applying a de novo review, argued that the executive is entitled to withhold, and again, this is going to be a theme throughout, budget request documents due to executive privilege afforded by separation of powers doctrine. And further argued that TPM lacks standing to seek enforcement of the publication provision of the Superior Court order, and that the publication provision is not enforceable from a private right of action, and that even if the disclosure of the requested documents is required, Superior Court still exceeded its authority by requiring disclosure of prospective documents, which gets us into the, both 2019 at the time and prospective documents going forward. We go through the waiting period. There were status hearings. There were, other filings. Eventually, last year, the Court of Appeals rejected the mayor's invocation of executive privilege. But it left it just at the separation of powers doctrine. It didn't weigh in on executive privilege in any other context. It stayed away from more broadly ruling. And, the conclusion was that the Superior Court did not err in ordering disclosure to TPM, the requested budget docs, or ordering online publication of the docs relative to DC FOIA. So it vacated and remanded the portions of the order requiring publication under 2-536 that did not include the budget request documents that the TPM wanted. So obviously 2-534 talks about the exemptions that are available, including interagency or interagency, letters, memorandum, etc., which would not be available except in litigation. And then, we have 534E incorporates deliberative process privilege, attorney work product, and attorney-client privilege. That's explicitly in the DC Code, and the Court of Appeals, reinforced that point by stating the law could not be much clearer. And then, we've got 2536A, which makes, is the proactive disclosure requirement. Now, obviously, everybody here has heard from us, particularly me, on the issue of proactive disclosure, and we're still in the process of working with many offices to get proactive disclosure fully up and complied. But that said, the court points out that in 2004, the council added a specific new paragraph to make public, quote, budget requests, submissions, and reports available electronically that all the organizations transmit to the Office of Budget and Planning during budget development process, as well as reports on budget implementation and execution prepared by OCFO, including baseline budget submissions and appeals, financial status reports, strategic plans, etc. So again, the court pulls this out and says the council has written that paragraph 6A has always required that the mayor make these documents public, period. So again, the Court of Appeals basically saying the law is extremely clear in this case. Whoop, did I jump? There we go. So, we, in 2022, the amendment happened in DC FOIA, and at the time, the council said the mayor is consistently failing to make public the documents in paragraph 6A, as the mayor acknowledged in the supplemental brief. Amendments required the deliberative process privilege inapplicable to the agency budget process request documents described in 6A, and TPM was seeking through FOIA. So the main things that the Court of Appeals looked at was whether the separation of powers doctrine exempts the agency budget request documents from disclosure. They did an analysis of the applicable different principles of separation of powers, whether the mayor has exclusive authority over budget, and whether 6A interests, 6A itself interferes with the mayor's functions. And then they also asked the set of questions whether TPM could seek to enforce 536A and B, including whether they had standing and whether the Superior Court, one, exceeded its authority in requiring 536 disclosure, and then whether it erroneously granted, prospective relief. And obviously, this is, I apologize, that's essentially the same information. So following all of that, it was remanded for those portions, and TPM ended up filing a motion for contempt and for further injunctive relief, asking, Superior Court to hold the district in contempt of the order requiring the district to produce to TPM and to post online documents requested. Obviously it was despite the order, and then the further injunctive relief was it wanted the online budget materials posted, and continually posted on an ongoing basis. End of last year in November, the district filed a motion opposition to it, contending that it was working in good faith to identify and produce the additional responsive documents when TPM had made its motion for contempt. TPM filed back beginning of this year. TPM filed a notice of recent developments and called the court's attention to memorandum to all deputy mayors and agency heads issued by the chief of staff, instructing them to refuse to produce to the council, quote, any agency's budget enhancement requests such as Form B submitted, et cetera, et cetera. And then, TPM's argument was that instruction contained in the memo is directly contrary to both the Superior Court and Court of Appeals holdings, and that issuance of the memo was further evidence the mayor was in contempt of the court's orders and would not comply. So again, we have TPM filing for contempt and further injunctive relief. In February, the court issued an order granting in part and holding the district in contempt and set the deadline for the production and plan for further action, up to and including the online posting. End of that month, heard the motions, arguments on contempt. On March 4th, the district produced the documents, and then a couple weeks later, having reviewed them, TPM represented it was satisfied with the district's production in response to the February 11th contempt order, and so the court vacated the contempt sanctions and held them any other injunctive relief in abeyance in accordance. So, there's still an ongoing issue regarding the online posting, and there's an ongoing issue regarding the attorney's fees. The deadline for filing on the motions for attorney's fees is the end of August. The next status hearing is next week. So for those who are interested in this and like me, are fascinated by how FOIA and FOIA litigation moves, maybe something if you have the time to catch. All right, we're going to move on to another Superior Court case, Chicago Justice Project v. District. Chicago Justice Project, a public justice organization, filed suit to compel MPD to release certain records concerning the gang tracking and analysis system. It has a proprietary name. I apologize, I don't remember it off the top of my head. It was basically a dispute regarding the advance fee that MPD regarded for FOIA review, and a comparable amount that CJP, Chicago Justice Project, was demanding in attorney's fees. As of mid last year, CJP filed for a motion for an in-camera review, asking the court for requiring the district to furnish copies of just a representative subset of 37 records that were withheld under 2534A3A, investigatory records compiled for law enforcement purposes, to the court, and for an in-camera inspection, and then to review and to see whether it had been lawfully applied and segregable non-exempt information was there being withheld, and should it be disclosed. So about a month later, a little over a year ago, the district filed an opposition to the plaintiff's motion for the in-camera review and a cross motion for enforcement of the settlement agreement, which preceded, and I'm not going to get into because it's just very bureaucratic and not material to the FOIA question. The court did in September hear the parties' arguments for the motion and took the motion for in-camera review under advisement. So the district said, we don't want the court to engage in in-camera review of these 37 representative records. And it said, in terms of the settlement agreement and the terms of the settlement agreement, preclude CJP from litigating the request for in-camera review, and under the terms of the agreement, they'd waive their right to any further production. And it further contended that on the merits, its most recent production at that time in bond indices satisfied FOIA, and that in-camera review by the court was not warranted. So, take us to the beginning of this year. The court denied both the motion for in-camera review and the district's cross motion for enforcement of the settlement agreement. Double whammy on both parties. And the court ruled, that the terms of the settlement agreement did not, in fact, present Chicago Justice Project from litigating the request for in-camera review, and that CJP had not waived its right to further production. But then the court addressed the substance and found that the district had adequately justified its reliance on the law enforcement exemption, and therefore they didn't need to engage in an in-camera review of those 37 documents. So right now, the parties are in discussion, trying to work to an agreement, and there will be a status hearing, which is currently scheduled for early September. Okay, I mentioned a couple of times prior, DC Open Government Coalition in litigation with the district. This suit goes back want to say a year and a half, not quite 2 years. The Open Government Coalition filed suit against the district, specifically via Octo, seeking an accounting of the backlog of the public record requests, FOIA requests, submitted through the older, now replaced FOIA Express public access link. I think everybody on here, except for our newer brethren, worked on the FOIA Express platform before we moved to GovQA. Last December, following motions hearing, the court issued a split decision and it granted partial summary judgment to both sides. So it upheld Octo's denials of Open Government Coalition's first 4 FOIA requests, which asked for tallies of pending FOIA requests on specific dates. And the court said these requests necessitate creation of a record. And we all know agencies are not required to create a new record under FOIA. And it stated because the total number of requests in a certain status was not already a data field in FOIA Express, and Octo did not regularly produce reports showing that number, the FOIA officer was required to perform analysis of FOIA Express data to ascertain the number. So accordingly, the court concluded that responding to the plaintiff's first 4 requests required creation of a record. And I'm sure almost all of us have at one time or another relied on having to work with the requester to say, we can provide records, but we will not create a record or conduct new analysis. In terms of the 5th FOIA request, the court found that Octo had failed to meet its preservation obligations, and it had converted the data that OGC was requesting into a, quote, unstitched format while migrating it from FOIA Express to GovQA. So in other words, the data was not connected and ready for an end user to be able to access. And so while Octo assured the court that FOIA Express data would remain preserved in an accessible state, Octo later argued that the old data had become so inaccessible that it would take more than 8 hours to search, exceeding the time limit imposed by DC FOIA. So the court found this is an inadequate argument. OGC is entitled to summary judgment in this request, and it ordered the district to produce the responsive records regardless of the time now required to respond to that 5th FOIA request. That is just going to be very difficult for everybody to read, so I'm going to read most of it to you. And before I post the deck, I promise I will fix slide 37. So the court issued an order granting, the reconsideration, finding that the district misconstrued the court's order as a sanction and said, considering the situation as a whole, the transition to a new platform, the representations to Judge Lee, who had the case for his elevation to chief, and the timing of the plaintiff's request relative to the transition, it was not reasonable to fail to conduct a search while the data was intact before it got migrated over from FOIA Express to GovQA. And the court found that the district had not carried its burden to establish that a reasonable search during the operative window would have exceeded 8 hours. Had they shown or had data that showed that, the court probably would have been persuaded. And therefore, they've not adequately explained the search that it did conduct. So while the court acknowledged its order required clarification, not necessarily as a sanction, declined to consider the result, and it found the district did not raise any exemptions as a basis for withholding of records in response to that 5th request, nor did it raise an exemption during the briefing on summary judgment. So the court had no duty to determine whether exempt material could be segregated. So it amended the mandate to make clear that it was not a sanction for the district to search and or produce records responsive to the 5th request, but provided it might redact or withhold material covered by a valid, 2-53, in this case, probably, 6, but any of them, exemptions, and may assert a segregability argument if one arises. And it gave OGC the ability to seek court's review of any redactions and withholdings. Now, we just talked about that, about in-camera review. So what it's saying is OGC can seek either in-camera review or another remedy if and when it comes to it for redactions and withholdings. And, one of the lingering issues with this case and the prior case that we talked about is with respect to costs, the court found that the issue wasn't raised in either of the parties' cross motions for summary judgment. and it wasn't addressed sua sponte in the court's order. So a motion for reconsideration was not the appropriate venue for raising new arguments not raised in the previous motion. So it said, supplemental briefing on the issue has to be decided with the plaintiff's motion for attorney's fees. So right now, that's where we're at. The district has appealed to the Court of Appeals. OGC cross appealed. This week, the district filed opposition to OGC's motion for attorney's fees, and this is where we're at. Is currently, this is, we're waiting on scheduling of a preliminary hearing at Court of Appeals. This is currently where it stands. You can always watch during the monthly BEGA board meetings. Director Allen usually provides updates on these cases that we follow. So you can either check the court's website or, as I say, during the BEGA board meetings, Director Allen, we provide dates when we have them. All right, so the Council of the District versus Mayor Bowser. This takes us back once again, and although not fully a FOIA issue, this again gets to the executive and legislative division regarding documents. So the council filed, complaint for declaratory and injunctive against the mayor, alleging that she refused to provide the council with certain budget enhancement requests for the, to the committees. Because of the timeliness, the court heard this on an expedited basis, and in May, the court granted summary judgment with respect to the council's claim for the request for FY25 and 26, because the council seeks the documents, quote, to assist in its consideration of the FY27 budget, which is currently under review and scheduled for votes. Now, at that point, they were scheduled for votes June 9th and 23rd. We know that didn't quite completely work out. The court finds expressly that there is no just reason to delay entering judgment and injunctive relief as to this portion of the claim. Beginning of June, they had the scheduling conference for the issue of further injunctive relief. It was continued to next week, and I do have that date. It's next week on the 24th at 10 a.m. in virtual courtroom 415. So for those for whom this is either interesting or important, that is our next known date. All right, I'm going to move us into, though not directly related to DC FOIA, we're going to talk a little bit about federal FOIA litigation. There are some key cases that I think are on point for us. Okay, so the first one is the America First Legal Foundation versus Jamison Greer. This was before U.S. Court of Appeals for DC. A public interest group, America First Legal Foundation, was suing to compel Office of Special Counsel to investigate whether a federal agency arbitrarily denied the public interest group's FOIA request. So the district court had dismissed the group's claims on the merits. However, the Court of Appeals concluded that, despite the fact that AFL asserted that it, had standing, the Court of Appeals did not agree, and it said that this group lacked Article 3 standing to pursue claims and found that an organization lacked standing to sue the Office of Special Counsel to compel it to investigate DOJ's FOIA policy, and that deprivation of a procedural right without some concrete interest that is affected by the deprivation is insufficient to confer Article 3 standing. So, that's a significant statement to say that, deprivation of a procedural right without some concrete interest, this is longstanding policy relative to information. So OSC's failure to investigate DOJ for failure to determine the documents is not a concrete injury, since any causal connection between failure to conduct the investigation and failure to comply with the document request is speculative, and the appellant did not show how a favorable judgment would lead to redress. It found that 5 U.S.C. 1216 requires the special counsel to investigate FOIA violations, but it does not create any entitlement for a requesting party to receive information. And so they vacated and remanded the case. This made some papers and some news covered this. Campaign for Accountability versus DOJ. Nonprofit group sued DOJ under FOIA. They were initially seeking all of the Office of Legal Counsel opinions, total, all of them. And then after multiple rounds of litigation, only 3 categories of opinions remained in dispute. One's resolving interagency disputes, one's concerning adjudication or determination of private rights, and then those interpreting non-discretionary legal duties. So the U.S. Court of Appeals for the district found that federal FOIA does not require government to disclose DOJ OLC opinions that resolve interagency disputes, concern adjudication or determination of private rights, or interpret non-discretionary legal duties, the 3 categories that were still in contention. And again, here we see a phrase very much like the prior case, held that informational injury is sufficient to establish standing for claims brought under the reading room provision of FOIA. That's an interesting distinction from, the prior case. Office of Legal Counsel opinions related to adjudication to the 3 categories are not, quote, working law subject to disclosure under FOIA's reading room provision, however. So it affirmed the district court's decision that their request, the public interest group's request for opinions concerning private rights and non-discretionary legal duties were not disclosable under FOIA, and reversed the court's decision that they were entitled to see opinions resolving interagency disputes. So a split result for the appellant. And again, interesting that they held that informational injury relative to the reading room provision will establish standing. American Wild Horse Campaign versus BLM. So this is another Fed FOIA case in which the American Wild Horse Campaign sued BLM for attorney's fees and costs after BLM was finished producing its responsive records to the FOIA request. Last July, the court held that the campaign was entitled to attorney's fees after its lawsuit was what prompted the Bureau to complete a search and release 3,500, give or take, pages of documents. And BLM kept shifting its position, including in pleadings. And that showed the court that, the production only occurred because of the court orders and the continued efforts of the campaign, the American Wild Horse Campaign. And the court was fairly clear about that. It also found that it was unnecessary to determine bad faith, to conclude that BLM, lacked a reasonable basis for its delays, including a late response, motion to dismiss, and a very slow agreement to coming up with agreeable search terms. The court said that the campaign reasonably spent 36.2 hours drafting a 23-page opposition to a motion that challenged multiple aspects of its request. And so the court, said that fees for reviewing the agency's final production were appropriate to confirm that nothing remained to litigate after nearly 2 years of litigation. So the motion for fees and costs was granted in part and denied in part, but substantively, the FOIA requester prevailed on the issue of being compensated for the time it had to, basically work to push. So this next case, Carlton Theodore Landis v. Federal Bureau of Prisons, case number 21-0504, the DC district. It's another federal FOIA case. This was an inmate at a federal penitentiary, who challenged the responses on his FOIA request to both Bureau of Prisons and OPM. The FOIA request sought all data fields. This is going to get all my FOIA officers today, I think. All data fields concerning all employees of the Bureau of Prisons, to include each employee's name, title, series, grade, salary, and duty station for the calendar years 2017 and 2018. Now, OPM did have, because these are federal employees and personnel management have it, they had responsive records in their database. But obviously, in consultation, which is a process I think most of us have gone through, BOP, in conference and in consultation with OPM, pushed back, and the court found that Federal Exemption 6 allows OPM to withhold the names and duty stations of BOP employees, and that the records maintained in the database qualify as personnel files within the scope of Exemption 6. BOP employees have a substantial privacy interest in their names and duty stations, and the court stated that information that reveals little or nothing about an agency's own conduct does not further federal FOIA statutory purpose. And further, the court found federal government has plausibly asserted that releasing the names and duty stations of prison employees would cause foreseeable harm by opening them to pressure from inmates to commit illegal acts under duress and subject them and their families to being searched on the internet, otherwise located by prisoners, former prisoners, or their families. I think the court got this one right, and I know that many agencies have gotten requests for personnel records and information that clearly would not reflect on an agency's performance, but would be, clearly subject to privacy. So the court just granted the government's motion for summary judgment. However, the prisoner, I don't know if he's a former prisoner now, but he was in a federal penitentiary, and there is an appeal now pending. So we will continue to brief as we see how this goes. I do not expect that U.S. Court of Appeals is going to strike any of this down, but that's not my job. So this is the point where everybody is saying in their head, someone please make him stop. So with a few other things, I'm going to wrap it up and take any questions. So we have additional sources here for interpreting FOIA and requests. This is where the FOIA regs live. This is the link to the MOLC opinions. There's other case law. We're always happy to provide. We can't do your research for you, but if you've got a novel or unique question, we can do a limited amount. And if you need to put in a formal request for, an advisory opinion, obviously you're always welcome to do that. And that would go to the chief counsel, who would then, work with the director, and it would get scheduled. Additionally, you can find our FOIA advisory opinions on our website, open-dc.gov. Many agencies have program manuals. In this case, I believe this is an MPD FOIA manual, but you can look around for those if you need additional samples or guidance. This is the DOJ specific guidance page, and then obviously the archives have OGIS, which I think today just completed its major annual conference, and there's going to be information coming out of that. So let's talk about the FOIA webinar series. So last week, many of you attended my colleague Joan Lelma's presentation on misapplication of DC FOIA exemptions. I just finished, some level of 2026 legislation litigation update. But now let's talk about the future. Next week, my colleague, who's joining us today, Brandon Lewis, is going to be talking about contracts procurement and DC FOIA. That's going to be a good one. Another good one is going to be Chief Counsel Louis Neal's presentation on DC FOIA appeals, basically MOLC opinions, and, analysis and insights that come out of the appeals process on DC FOIA requests. Now, that one on the 30th in 2 weeks is going to start, especially at 3 o'clock, not 2 o'clock. And we're going to have a FOIA officer social like we did a while back. And so although the event, I believe, is going to be virtual, I haven't confirmed whether we're going to have folks here if they want to come over. But if we do, we'll let you know by next week. But following that, we're going to have a location downtown, not too far from us. We're on 15th between K and L. And we're going to invite anybody who'd like to join us to sit down and socialize and, talk shop or not, but engage in a little fellowship. And then after that, getting into August, Director Allen is going to talk on a new topic that we haven't ever addressed before: electronic records, text messages, and AI, and the challenges that apply under FOIA in this crazy new electronic and AI-driven era. And then wrapping up, as we always do, we're going to have a presentation by our two friends over at the Civil Litigation Division, who do the majority of defense litigation for the district on FOIA, and they're going to be talking about how to prepare for even before you've had a civil FOIA case and also defensive litigation. That presentation you'll need to be at in person if you want to catch it. We won't be recording it, and there won't be a deck, so to speak, because the material is confidential. So FOIA officers can all attend that, but as I say, you'll need to attend that in person to get the benefit. And then at the end of that, Director Allen's going to moderate a Q&A with our AAGs, Brennan Heath and Adam Daniel. As always, this is how you contact us. I wanted to make sure you knew who me was, so there you go. And as I say, this will be available in the deck anytime. Reach out. We, like everybody, are we're working at pace, but we'll happily either address a quick or short type of inquiry as fast as possible. And if it's a need for an advisory opinion or something broader, we'll arrange for you to work with the chief counsel. And as I say, we'll take it into our formal pipeline and get you scheduled. And with that, I'm going to say thank you and stop sharing and see if we have any questions from folks in attendance today. And Brandon, let me know if we have anything in the chat.
There is nothing in the chat, Anthony.
Okay. And that's fine too, because it's a hot day and folks just had to listen to a lawyer who likes to talk himself dry. So I appreciate everybody attending. If there aren't any further questions, we will happily take them now or later. We'll post the recording and the deck on open-dc.gov as soon as possible, probably by tomorrow. And with that, I'm going to give you all back to your days and hope that everything goes well for everyone. And as I say, if we can do anything for you, happy to do so.